Now, tonight, the Attorney General, Godfrey Yabuadame, has drawn the anger of the NDC for his comment on their case before the court, which they interpret as seeking to prejudge the substantive one. Well, 3 NDC MPs, led by Minority Leader Haruna Idrisu, are asking the Supreme Court to strike down the passage of the e-levy law as unconstitutional. They claim Parliament did not have the required numbers to constitutionally pass the bill into law. The MPs wanted the Apex Court to actually injunct the implementation of the law until the substantive case is determined, but that did not happen. The Supreme Court denied them that, did not grant that application. Now, speaking to journalists, Godfrey Yabuadame, the Attorney General and Minister of Justice, said the NDC had presented no evidence to the court.
And I think on the failure of the applicants to establish a case clearly, it's also material to indicate that the court had earlier on even observed, just as I had stated in my affidavit position, that there were a lot of factual inaccuracies or factual uncertainties in the case of the applicant. You cannot go to court and you're not even sure of exactly the number of MPs that you claim voted to approve the e-levy bill, when that is actually central or fundamental to your case. They state that it's 136 or 137. How can you go to court without being sure of the numbers that you're talking about? And the numbers, no doubt, are very crucial to this action, because as we know, the current composition of Parliament, the absence of even one member of Parliament makes a difference. And indeed, as I contend now, the quorum for taking a decision in Parliament is 137 and not 138. And therefore, if you are an applicant for an injunction and you say that the number which took the decision was either 136 or 137, then to understand, you are even supporting my case. Because if indeed it is 137, then that shows that proceedings were valid and regular. And I was even expecting, when I received the documents, expecting, say, a video of the proceedings in question. And that's readily available. The proceedings of Parliament are captured on TV and shown even on GTV almost every day. So if you are diligent, you want to apply for injunction to restrain the enforcement of a law, and you think that the walkout allegedly staged by Parliament or members of Parliament at a particular time is crucial to your case, you definitely owe the duty to produce evidence of that. And there was nothing from the record of proceedings, the minute of the day in question, that there was a walkout. And if there was a walkout, what stage the walkout occurred? And if it occurred at a certain stage, how many people engaged in the walkout? And that for me was just fundamentally defective.
The next one is a substantive case. What should we expect?
So we expect, of course, I mean, if indeed the case is anchored on the same facts, I believe that your guess is as good as mine. And I do not think that the facts can be manufactured. The facts are as recorded in the record of proceedings in Parliament, the votes and proceedings, which actually constitute the minutes of every day's proceedings. And that is what the case is about. It's as simple as that.
What do you think the timelines for the substantive case should be?
For me, as the principal legal advisor to government, my concern is to ensure that the laws of Ghana are obeyed. My concern is to ensure that proceedings of Parliament are regular. And as I indicated, I do not even go about dictating to Parliament exactly what they do. It is only when there's an unconstitutionality or a statutory infraction engaged by Parliament that I will definitely write to them or advise them somehow. And the point is that now the way is paved for GRA to embark on this statutory function of collecting revenues under Act 1075. Yes, the court has a procedure for determination of cases. I expect this matter to be dealt with as expeditiously as possible.
So for the record, is it your view that the monies collected by GRA can be spent by government?
Well, I think that the answer to the question was actually provided in court today. The court indicated that, GRA, the injunction is dismissed, meaning that there's nothing preventing GRA from collecting the revenue in the first place. Secondly, there's no order made by the court directing how the revenue collected today should be disbursed. So government is free to utilize the revenue for its developmental activity and for the various projects that it has promised the people of Ghana.
Well, these comments from the Attorney General have actually drawn the fury of the legal team of the 3 NDC MPs, and they say that the Attorney General, Godfrey Dame, has a habit of prejudging cases and must be stopped. Let's hear from Eduji Tamaklo.
We've had attorney generals of this republic. Have you seen this kind before? You remember not too long ago, even after the Supreme Court gave an injunction order against the NDC MP for saying off. He met the media once again and said what happened to Adamu Sakande should happen to the NDC MP, knowing that there was a substantive matter to be determined. Okay? Knowing that there was a substantive matter to be determined. So it is part of his making, okay, to prejudge matters that are before the court. But I honestly don't blame him. Again, like the child whose kennels have been cracked for him.
What does that idiom mean in this context?
He has no appreciation of humility.
His palm canal has been opened for him by...
I'll leave it there.
There are those who would also say that the specific case of the NDC that you have sent to court, that you cannot prove it, and that is the same position that the Attorney General is making, and that you see the court has rejected in terms of the course of action argument he sought to make before the court. As an Attorney General and as a party to the suit, he's entitled to make those arguments, and no one should be able to say by that basis, to say that he has prejudged the case.
We are the two lawyers on record. I represented the plaintiff. He represented the defendant, correct? After courts, I never spoke, and I have decided not to speak for a reason, right?
Yes.
Because they are ethical matters. Until he decided, okay, and that childish commentary where he called journalists to his office. I mean, as lawyers, even when we leave court, there's a standard that is required at the bar. Okay? He's even my senior at the bar and ought to know better. And so when he decides to descend this law, I need to respond to him in equal measure. And let it be on record that I have said that this Attorney General has no regard for candor and honesty. If not, he will not appear before the apex court of the land with the 29th March 2022 votes and proceedings, knowing very well same have been corrected and that correction has been adopted. It is the lowest that I have seen of an Attorney General. And let that be on record.
So essentially what you're saying is that when the arguments for and against the injunction application was heard, the court had not gone so much into the substantive case.
No.
And so his comments...
In fact, even the judges were clear. The judges were clear. I even want, because the affidavit in opposition Emefa raised the issue of course of action, I even wanted to respond to that. And the judges said, no, what we have before us is the injunction application. Demonstrate to us the damage that will be caused to the plaintiff. A, B, C, D. Very strict. So what is the business that he's engaged in?
So you do not think his comments, and I quote, he says you went to court with speculation and conjecture. You don't think it's something that he, as Attorney General, and for a case that is still pending before the court, he should not have gone on to make such comments?
I mean, the position of the judges, unless, of course, I didn't understand their judgment.
Well, that's not the only comment that has drawn the fury of the NDC lawyer. Eduji Tamaklo has also been responding to Godfrey Dame's description of his performance in court as an embarrassing spectacle.
You saw what happened in court today. It was an embarrassing spectacle. The lawyer clearly was not able to demonstrate any form of irregularity with proceedings in Parliament. The court asked him, so is there any record that indicates that X number of MPs worked out at a certain stage? Is there any record that shows that a head count of all the MPs in Parliament was taken? That was not done. He absolutely said no. There was no evidence indicating whether there was a head count of the number of MPs present in Parliament who voted to support the bill. There's also nothing provided by the lawyer that indicated that there was a walkout by X number of people in Parliament. So I think we should ignore all that propaganda. In court, we adduce evidence of matters that we can prove, and we apply the law to a resolution of the issues in question. And clearly, the proceedings were quite obvious that there was no form of irregularity whatsoever in the proceedings of the day to 29th March 2022. And in any case, as I indicated, that if indeed, assuming without admitting that it was only or the entire minority walked out of Parliament, the proper quorum for decision making is, as I stated, 137.
Let me bring in lawyer Eduji Tamaklo here on Top Story. Good evening and welcome to Top Story tonight. So first, what exactly is your problem with the AG statement? Is it not the case that he only described what transpired in court, or is it your thinking that he just manufactured it?
So I'm also describing his conduct as a very dishonest Attorney General. If he has any respect for the office that he occupies, and also as the leader of the bar, there is a standard practice of how we communicate. He is my senior at the bar. Right from the time we've issued the writ, filed the application for injunction, for ethical considerations, I've restrained myself from all interviews. Even yesterday, after the ruling, I never spoke because of the ethical considerations. Only for the Attorney General to invite journalists to his office and set himself up with a view of attacking my person and my professional competence. To that extent, I'm entitled to say this Attorney General has no regard for candor and honesty. Like I pointed out, he filed an affidavit deposing to the fact that 266 MPs approved e-levy. Clearly, he knew that his AG that he submitted in court was corrected, and that correction was adopted by Parliament on 31st. If he has any regard for due diligence, if he has any regard for candor and honesty, and he wanted the court to have a full appreciation of what transpired in Parliament, he ought to have brought, and we did that. So, you see, like I told you, I didn't want to comment on this whole injunction and what have you until he decided to to the gutters. Unfortunately, this is the Attorney General that we have to contend with. He sees himself more of an MPP propagandist than the Minister of Justice. I am not going to take that from him.
Well, when you say he sees himself as a propagandist, how exactly? Why would you say that? That's the Attorney General and Minister of Justice. Why then do you describe him?
Attorney Generals. You've seen Attorney Generals after court call media men to their office to engage in propaganda rants. When was the last time you saw that?
Did he break any rule or law in his commentary? You would say, Eduji, if I may, did he break any rule or law in his commentary about the case yesterday?
In any case, is he not the lawyer on record? Has the substantive matter been determined? Emefa, has the substantive matter been determined?
And in his comment,
the matters that he called the journalists to discuss with them, were they matters canvassed in the ruling by the Supreme Court? I have the ruling, the 5-page ruling by the Supreme Court. Matters that he was saying out there, which one of them was in the ruling by the Supreme Court? So quite clearly, he was on a euphoric of his own, and his deliberate agenda to get at my person, and I'm not going to take that from him.
Personally,
and let it be on record, and I'm saying that our Attorney General is simply dishonest.
Personally, Eduji, is there any part of his commentary you deem unfair to your person?
How would you want me to describe your work today as a journalist? Was that part of the ruling of the Supreme Court? I was a counsel for the plaintiff. After court, I never spoke. For good reason, because I knew that the substantive matter had not been determined. And he is my senior and the leader of the bar. I mean, he should know better. He should know better. So for him to have decided to descend into the gutters, it is for me to let him know and let the people of this country know. Contrary to what we all saw, your Attorney General and Minister of Justice goes to not a district court, but the Supreme Court to say 266 MPs approve the e-levy. What more is dishonest than this? What more is dishonest than this? And you call what I did to be embarrassing. I prefer to do an embarrassing thing than to be a dishonest Attorney General.
Well, following the comments, though, I would want to find out what your clients are thinking. Are they convinced he's prejudging the case? What exactly have they been saying?
Quite clearly, an Attorney General who invites the media to his office and now begins to do merit review of the case. What else is he doing? And I'm saying that, you see, this is not the first time. The last time was this Assin of injunction. Then he was out there. What happened to Adamu Dramani Sakandi? What happened to J. What is it that he knows? What is it that he knows? A matter that is before the court. Yes, to be determined. What is it that he knows? Please. We have had attorney generals of this republic. This law, we have never had it. And let the record reflect. Me, if he tries it on me, I will go for him.
Well, we will not do that right here. But let me find out whether there are remedies.
I just want you to know.
That's fine. That's fine. I wouldn't want personal attacks at this point, but I would want us to deal with the issue.
How do you consider his expressions?
That's fine. Mr. Tamaklo, I'm asking you questions. Maybe we'll just deal with that and then substantive issues, please. Are your clients considering any remedies, if there are any, in this particular instance, because you've raised valid concerns, I'm
here to have conference with my client related to that.
Well, I'll let you go then. We're grateful for your time. That's a lawyer, Eduji Tamaklo. There he's representing the 3 NDC MPs that are at the Supreme Court over the e-levy implementation. He's representing Kujato Ablakwa, Mahama Yariga, and the minority leader, Haruna Idrisu. Let me bring in lawyer Martin Pebu. We're grateful for your time. You've frequented the Supreme Court a number of times, and you've been monitoring this particular case. At least you've heard the commentary of the Attorney General. You've heard lawyer Eduji Tamaklo also. I'd first want to pick your thoughts on this back and forth between the Attorney General and the NDC side on this particular issue. Monitoring what you've seen or from your own reading, is there a particular rule or law that has been broken?
Well, Emefa, there are rules, but the problem is that I would not be able to take out my neck to say any the Attorney General statement specifically broke those rules. Okay, so let's mention the rules. It's for education, and after we are done, if the parties wish to contest this, they will have to take it to the General Legal Council. You say, yes. So what it is that the rules say that a lawyer should not use abusive, offensive, or misleading language. Okay, so we have an LI called 2423. That's a legal etiquette rules. Okay, that's rule 11. Yeah. Now, so the language should not be abusive, offensive, and misleading. But the question is, what is offensive, abusive, or misleading? Now, the point is that let's be very specific. As lawyers, there are certain words that are used in court that ordinarily will appear offensive to an outsider, but in court, that's the language we use in respect of the work that is done. It's not for the human beings themselves. So you will hear that this application or this suit is incompetent. It is hopeless. It is full of conjectures, speculations. Yes, they are standard. Initially, when you start here, sometimes you can take it personal. But with age at the bar, you accept that that is the language. So you read affidavits of this in response from another lawyer. You say, my lord, this whole application is so incompetent. It is hopeless, misconceived, and all that. That's the language we use in court. But for the work, we don't usually call the lawyer himself as incompetent because that is another matter. Usually, in actual fact, under the law of slander, if you refer to a lawyer as incompetent, you are, courting a lawsuit for slander. Yes. Okay. So when I listened to the Attorney General's words that they were embarrassing, because as I've already told you that we say incompetent, hopeless, full of conjectures, and he even used some of those words. It sounded more like what we hear in court every day. Okay. Now you come to ADG. To be very frank, Emefa, I'll be very frank with you. At a point, I thought I should have stopped him. Because to say that the age is dishonest, no, you should have. I wish if there were a medium where I could have stopped both of you, I would have, because that went too far. That one we have to be very plain. And even I thought that to the extent that the age's comments had come earlier, if somebody was coming to respond, you would guard against the very thing that you're accusing the other person of breaching. The very rules you are accusing the other person of breaching. Because it's in the Rule 14 that the regulations, that one lawyer should not make misleading or false statements about the services of another lawyer. So if your work is being said to be full of propaganda and you say no, that's below the belt, it's false or misleading, then the remedy is to report to the General Legal Counsel. That is it. You say, so maybe we are all learning. So in future, I think that you would maybe conduct the interview off air first so that you can edit it, because this definitely went a bit overboard.
I appreciate that, and where I fought it, I apologize for that as well. But beyond the personal attacks, I'd say the commentary also about prejudging the case is another issue that was raised. From what you've listened to, is there a prejudging of the case? Or what exactly are the remedies you'd say that are available?
Yeah, so to get the context, initially I thought there was one before, a comment before. I saw it somewhere. When I asked that I'd be finished with the information, I thought I would see that. But the ones that were played for this story, I think those were post the Supreme Court ruling. After the ruling, we all criticize Supreme Court. We give our critiques. We say, oh, this ruling is not good. This is, all the, of course, not offensive words, but people have various words they use to critique. And then others have all the words they use to praise. So when it's after, the standard is different, that it shouldn't be scurrilous, don't insult and all that. But before, the standard is that don't prejudge, don't go into the merits. So if somebody were to say, I hope to win my case, the other person will lose. No, that's not prejudging. Yes, I'll win, you will lose. No, that's not prejudging. You haven't gone into the merits.
Okay, but the concern, at least from what I hear the plaintiffs say, is that there's a substantive case that is yet to be heard. This was just the injunction part. So it appears that the comments that were made after this injunction case seem to predetermine what is to come in the substantive case.
Well, if I come back to this, that maybe because I haven't had enough notice. But what I heard, I thought he was responding to the application when he said it was full of conjectures, propaganda. I thought they are talking about the application that the Supreme Court had just determined. That's the injunction one. So if I didn't sit to hear that he was commenting about the one that is yet to come.
So the media men were asking about what is to come as well, and that was the response to it.
There was. Okay, then I haven't heard. You remember I was just in a meeting when you called that we could. So what I heard, I thought that was on the injunction one.
We appreciate the education, Mr. Martin Pebu, as always. Thank you so much for joining us here on Top Story, brought to you by Vodafone. Newsnight is coming up shortly after this break.